Hello everyone, welcome back to SEBIGRADEA legal classes. I'm Rajni Yadav, and in today's class I'll be teaching Consumer Protection Act 2019. And today in this class we'll be covering the main aspects, the important portions which are generally asked in exams from this subject. And we'll be doing a quick revision in today's class. Okay, so let's get started. Yeah. Earlier, we had Consumer Protection Act 1986, right? So what happened in 2019, it was replaced by Consumer Protection Act 2019, and which this new act of 2019, it got President's assent on 9th of August 2019. It extends to whole of India. The earlier act of 1986, it used to extend whole of India except the state of Jammu and Kashmir. But when in 2019, our Jammu and Kashmir Reorganization Act came, it also started extending to whole of India, including Jammu and Kashmir also. Right, now let's read the aim of this act. The act is designed to protect the consumers and provide them certain rights while buying goods and services. It protects and strengthens the rights of the consumers by establishing authorities, imposing strict liabilities and penalties on product manufacturers, electronic service providers, misleading advertisements, and by providing additional settlement of consumer disputes through mediation. Right. So what you'll see is that in this new act, there's a new concept which is introduced. Now we have mediation also in this act. That is, you can go for the settlement of cases through mediation. The new act of 2019, that is Consumer Protection Act 2019, it also applies to e-commerce and teleshopping, right? So yeah, when the earlier act was there of 1986, then there were not e-transaction that used to happen, like online shopping was not there. So the applicability of this act was not on the electronic or e-commerce. So yeah, but now it extends to those transactions also. And it applies to teleshopping also. By teleshopping, we means when you see ads in television and you make purchases from there, then also this act applies. Now let's read important definitions from this act. They generally ask from this portion, right? They can ask, where is consumer defined, where is complaint defined, where is misleading advertisements defined. So you should know which section is talking about what. So yeah, first of all, we will read what is consumer. Consumer is defined in section 2(7), and it means any person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised, or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for consideration paid or promised or paid partly or partly promised, or under any system of deferred payment when such use is made with the approval of such person but does not include a person who obtains such goods for resale or any commercial purpose. Right. So basically what it is saying is consumer is someone who buys something, that is to say, who buys any good for consideration, right? Something of which is of value in the eye of law, and that is to say, for a consideration which has been paid. It may happen that it is paid in absolute, in full at the same time, and it may also happen that the buyer has promised to pay some due amount at later stage, right? So, but yeah, it does not include any of the goods that you have bought for the purpose of resale, or if you have bought anything for commercial purpose, right? Rest other things will make you a consumer if you buy it. But if you buy it for reselling it, or you are buying it for commercial purpose, then you will not be called a consumer, right? It also says it is a consumer is any person who hires or avails of any services for a consideration which has been paid or promised or partly paid and partly promised under any other and under any system of deferred payment and includes any beneficiary of such service other than the person who hires or avails of the services for consideration paid and promised or partly paid and partly promised, or under any system of deferred payment when such services are availed of with the approval of the first mentioned person, but does not include any person who avails of such service for commercial purpose. So similarly, it is also talking about a consumer can also be the person who hires or avails any services, right, for the consideration of for some consideration which he pays which he may pay there then and there itself, or he may partly pay and pay the remaining part later. But it also does not include who avails or hires any services for the commercial transaction or commercial purpose. So who is a consumer? Who buys any goods or services, right? Goods and services, but does not include if you're buying it for any commercial purpose or if you're buying the goods for the resale purpose. Yeah. Now let's read the other definitions. Advertisement. Section 2 clause 1 defines advertisement, and it means any audio or visual publicity, representation, endorsement, or pronouncement made by means of sound, light, smoke, gas, print, electronic media, internet, or website, and includes any notice, circular, label, wrapper, invoice, or such other documents. Who is a complainant? Section 2 clause 5 defines complainant, and complainant means a consumer or any voluntary consumer association. Complainant is a consumer or a voluntary consumer association registered under any law or the central government or any state government or the central authority, or one or more consumers where there are numerous consumers having the same interest, or in case of death of a consumer, his legal heir, a legal representative, or in the case of consumer being a minor, his parent or legal guardian, right? So basically, complainant is someone who is a consumer, right? Or a voluntary consumer association. And in case of a minor or in case of death of the consumer, his legal representatives will be the consumer, right? Now let's read. What is a complaint? Section 2 clause 6, right? Section 2 clause 6 talks about complaint, means any allegation in writing. So what is important? Allegation should be there and it should be in writing, made by the complainant for obtaining any relief provided under the Consumer Protection Act 2019, that an unfair contract or unfair trade practice or a restrictive trade practice has been adopted by any trader or service provider. So complainant is who will be complainant. Of course, the consumer will be making the complaint because he's availing the services. No, if he'll not be satisfied, he'll be complaining against it. And this complaint should be in writing. It is mandatory, and it is sought for some relief that you want under this act, and which could be related to an unfair contract or unfair trade practice or a restrictive trade practice. You might ask, what is a restrictive trade practice? Suppose you go to the shop to buy a fountain pen, right? But they say you can only buy the pen if you'll buy the refill. Like, you cannot buy them individually, right? You just can't buy one pen or the only refill. They say that you have to buy this in combination, you have to buy this in packet. So this is like restrictive trade practice. Unfair contract or unfair trade practice will be like, suppose you are going to the market to buy something, and what happens that the seller is not showing you variety of the article that you've asked, or sometimes you go to the market to buy things and they show you very pricey or overpriced materials, and when you ask for something, do you have anything in of lesser price of same thing, right? So they say they don't have it, or maybe they collude with other players or other sellers in the market who are there, and they decide that this will be the only price below which they'll not be selling. So this will come under unfair trade practice, right? Okay, so what is complaint? It is an allegation made in writing by the consumer with respect to any unfair trade practice or restrictive trade practice, or which has been adopted by any trader or service provider. B, that the goods bought by him or agreed to be bought by him suffer from one or more defects, right? So you can also make a complaint when the goods or services that you bought or hired, they were having one or the other defects, right? Now, the services hired or availed by him or agreed to be hired or availed by him suffer from any deficiency. So the goods, you can also make a complaint when the goods as well as the services are hit by some are suffering from some deficiency. B, a trader or a service provider has charged for the goods or the services mentioned in the complaint a price in excess of the price. When he is charging you so much, or he has overpriced the product in the market, then also you can file a complaint. E, the goods which are hazardous to life and safety when used are being offered for sale to the public, right? When you find that the goods are not safe for the public use, they are hazardous, then also you can file a complaint. So these are the circumstances in which you can file a complaint. First of all, unfair trade or restrictive trade practice has been followed, or the goods or the services that you avail, they are suffering from any defects, or the service provider has overpriced the products or the services, or if the goods are hazardous to life. So in these cases, you can file a complaint. Right, now let's read what is a defect that we just now discussed. Let's actually know what exactly defect is. Section 2 clause 10 defines defect, and it says defect means any fault, imperfection, or shortcoming in the quality, quantity, potency, purity, or standard which is required to be maintained by or under any law or under any contract, or as is claimed by the trader in any manner whatsoever in relation to any goods or product, right? So if any fault or imperfection or shortcoming is there in the quality, quantity, or purity or standard of the good, then it will be termed as a defect in the goods. Now let's go and read what is deficiency. Section 2 clause 11 defines deficiency, and it says deficiency means any fault, imperfection, shortcoming, or inadequacy in the quality, nature, and manner of performance which is required to be maintained by or under any law, or has been undertaken to be performed by a person in pursuance of a contract in relation to a service, and includes any act of negligence or omission or commission by such person which causes loss or injury to the consumer. B, deliberate withholding of relevant information by such person to the consumer, right? So deficiency is any fault or imperfection, shortcoming, or inadequacy in the quality, nature, or manner of performance which is required to be maintained, right? Something you were obliged or you were duty bound to maintain or to do, but you were faulty in that, right? So that will be termed as a deficiency. And it could be through, like, you were negligent, you were supposed to take care of something of the goods, or when you're providing some things, some services, then you were supposed to, make sure that the task is performed in full compliance of the rules and regulation, or something like that. If you were negligent in your task, or what you were supposed to do, then that will be termed as a deficiency under section 2 clause 11, right? Act of negligence or omission, or deliberate withholding of relevant information. If you were being negligent, or if you're or it may happen that you were supposed to give some relevant information to the consumer, but you did not give, then also it will be termed as a deficiency. Now let's read what are misleading advertisements. Section 28 defines misleading advertisement, which means an advertisement which falsely describes product or service, or B, gives a false guarantee to or is likely to mislead the consumer as to the nature, substance, quantity, quality of such product or service, or conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practice or deliberately conceals important information. Right? Section 2, clause 28 is defining misleading as advertisement, which is basically when you falsely, deliberately giving false guarantee or describing some product as good, which is not good, or telling about a service as a good service, which that it is not good, and which is going to, at the end of the day, mislead the consumer as to the nature, quantity, and quality, will be termed as a misleading advertisement. So yeah, let's briefly revise which section defines what. 2 clause 1 defines advertisement, and 2 clause 7 talks about consumer. 2 clause 5 talks about complainant, right? 6 is talking about complaint, 7 is talking about consumer, 10 is talking about defect, and 11 is talking about deficiency, and 2 clause 28 is talking about misleading advertisements. Now let's read what are the consumer rights. A consumer has the right to be protected against marketing of goods and services which are hazardous to life and property, right? And the right to be informed about the quality, quantity, potency, purity, standard, and price of goods or services so as to protect the consumer against unfair trade practices. The right to be assured, wherever possible, access to variety of goods and services at competitive market. It should not happen that you are just showing him one product or telling him about the one services only. No. He should be given lots of choices about the products and the services, and he should be allowed to choose whichever he likes. Right? The right to be heard and to be sure that consumer interests will receive due consideration at appropriate forums. The right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumers, right? He should have redressal if he is facing any if he's facing any of such problems like unfair trade practices or restrictive trade practices. He should be given the redressal mechanism, right? And right to consumer awareness. He should know what are his rights, where he can go, which court he can go, in how many days he should file the case, and all. He should be aware of all his rights. Consumer himself should know about all these things. Now, in this 2019 legislation, we have Consumer Protection Council. Okay, so first of all, we'll be reading about Central Consumer Protection Council, which has the power to establish this. First of all, we'll be reading about Central Consumer Protection Council. So the first question, and it is important, and they might ask, who establishes Central Consumer Protection Council? It is established by central government, right? And the Central Council shall be an advisory council, right? It's an advisory body, and the chairperson of Central Council shall be minister in charge of the Department of Consumer Affairs, right? So CCPC, that is Central Consumer Protection Council, is an advisory body, and the chairperson is minister in charge of Department of Consumer Affairs in the central government. Central Council will have such number of other official or non-official members representing such interests as may be prescribed, and they shall meet as and when necessary, but at least one meeting of the council shall be held every year, right? They can meet as many times as they want, but one meeting in a year is mandatory. They have to follow that protocol. At least once in a year. Now let's come to State Consumer Protection Council. Every state, so it is established by state government. Central Consumer Protection Council was established by central government. Similarly, State Consumer Protection Council is established by state government. For such state to be known as the State Council, the State Council shall be an advisory council. Chairperson of State Council shall be minister in charge of consumer affairs in the state government. It is just like that only, but herein everything will be with respect to the state government, right? And it shall also meet as and when required, but not less than 2 meetings shall be held every year. So as in the earlier case, in the Central Consumer Protection Council, 1 meeting in a year was mandatory, but herein at least twice. They should meet at least 2 times in a year. So this is the condition that they have to follow. Now, District Consumer Protection Council. It is also, the state government is the authority which is empowered to establish it, right? So state as well as District Consumer Protection Council both are established by state government, and it shall also be an advisory body, and the council chairperson of the district council shall be collector of the district. So here the in charge of this council will be the district collector. And in the previous one, it was the minister in charge of the consumer, minister in charge of the, who was the head? In the earlier cases, it was minister in charge of the consumer affairs. In district level, in the district council, the chairperson is district collector, but in state and Central Consumer Protection Council, the chairperson was minister in charge of the consumer affairs. With respect to state level, it will be of this minister in charge of the consumer affairs in the state government, and in Central Consumer Protection Council, it will be the minister in charge of the consumer affairs in the central government. Okay, now let's read about Central Consumer Protection Council. Section 10 talks about establishment of CCPA, Central Consumer Protection Authority. This is important. This section you should know. Which section talks about establishment of CCPA? That is Central Consumer Protection Authority. It is section 10. And it says, why is it appointed? So let's read. To regulate matters relating to violation of rights of consumers, unfair trade practices, false or misleading advertisements, which are prejudicial to the interest of public and consumers, to promote, protect, and enforce the rights of consumers as a class. Okay, so this is why this is appointed: to protect the rights of the consumer, to protect unfair trade practices, misleading advertisement, these kinds of things. For these things, it is appointed. Right. Now, what is the composition of CCPA? It shall consist of a chief commissioner and such number of other commissioners as may be prescribed. The headquarters of the central authority shall be at Delhi, and it shall have regional and other offices in any other places in India as the central government may decide. Now let's read powers and functions of the central authority. Section 68 talks about powers and functions of central authority, which says it has the power to protect, promote, and enforce the rights of the consumers as a class, prevent violation of consumers' rights under this Act, prevent unfair trade practices, and ensure that no person engages himself in unfair trade practices. Ensure that no false or misleading advertisement is made of the goods or services which contravenes the provision of this Act or the rules or regulations. Ensure that no person takes part in the publication of any advertisement which is false or misleading. So basically, when you read this, you'll get an idea that it is basically protecting the basic and the major rights of the consumers, like protecting the consumer from unfair trade practices, restrictive trade practices, or misleading advertisement, and enforcing the rights of the consumer, right? So this is what their basic function is. And for the above purpose, central authority has the following powers, right? So how will they ensure all those things? So these are the things which they can do. And so, yeah, how they'll do it? They can do it by inquiry or investigating what they can do is, for that, they can go for an inquiry or investigation to be made into violation of consumer rights or unfair trade practices, either suo motu or on a complaint received on the directions from the central government. So yeah, it's a right which is given to them. They can go for inquiry or investigation, either suo motu, that is by their own, or if the complaint is filed by the complainant, or that is the consumer, right? They can also file complaints before district commission, state commission, or the national commission, as the case may be under this Act. They can intervene in any proceeding before the district commission or state commission or national commission in respect of any allegation of violation of consumer rights or unfair trade practice. They can undertake or promote research in the field of consumer rights, spread and promote awareness on consumer rights, encourage NGOs and other institutions working in the field of consumers' right to cooperate and work with consumers protection agencies, issue safety notices to alert consumers against dangerous or hazardous or unsafe goods and services. Now let's read section 20. Section 20 talks about power of central authority to recall goods. If central authority is satisfied on the basis of investigation that there is sufficient evidence to show violation of consumer rights or unfair trade practice by a person, then it may pass following orders: recalling of goods or withdrawal of services which are dangerous, hazardous or unsafe, or the reimbursement of the prices of goods or services so recalled to purchasers of such goods and services, and the discontinuation of practices which are of unfair and prejudicial to the consumer interest. So, right, section 20 is basically talking about what are the powers given to the central authority, right? And it is basically talking about the power to recall goods, which is given to the central authority under section 20, right? So, they can recall the goods, they can ask for the withdrawal of services, they can ask for the payment of reimbursement of the prices which was paid by the consumer with respect to some goods or the services, right? And the discontinuation of the practices like unfair trade practices. So these are all things that the central authority can do. Power of central authority to issue directions and penalties against false or misleading advertisement is given under section 21. Right. So what all this authority, central authority, can do with respect to misleading advertisement, it is given under section 21. So let's read. If the central authority is satisfied that after investigation that any advertisement is false or misleading or is prejudicial to the interest of any consumer or is in the contravention of consumer right, it may order to discontinue such advertisement. As we read before, if it finds any advertisement or services or advertisement to be misleading or against the interest of the consumer, then it can ask to discontinue such advertisement or to modify it, right? Suppose if there's an ad, right, and which is targeting the consumers at large, which is targeting even a single consumer, which is targeting anyone. So through that advertisement, if anyone is targeted and it happens or it turns out that that advertisement is giving or saying or that advertisement is giving some false information or it's misleading or it is against the interest of the public, then this authority can ask for the discontinuation of such advertisement, right? And if the central authority is of the opinion that it is necessary to impose a penalty in respect of such false or misleading advertisement by a manufacturer or an endorser, it may by order impose on manufacturer or endorser a penalty which may extend to 10 lakhs rupees. So in the above case, if you do such kind of thing where you're misleading the consumers through misleading advertisement, that penalty can be imposed upon the manufacturers or endorsers to the extent of 10 lakh rupees. Right. Now, the central authority may, for every subsequent contravention by manufacturer or endorser, impose a penalty which may extend to 50 lakh rupees. So, right, when you will commit such kind of mistake, for your first mistake, you will be held liable to the extent of 10 lakhs. But if you repeat that thing, if you repeat that mistake and you still are advertising through those misleading advertisement, then the liability will be increased and it will be to the extent of rupees 50 lakhs. Now, where the central authority deems it necessary, it may, by order, prohibit the endorser of a false or misleading advertisement from making endorsement of any product or service for a period which may extend to 1 year. Right? If the central authority finds that if you're advertising anything and it finds that it is false or misleading, then it can ask you to not continue with those advertisements for a period of 1 year. Right? Central authority may, for every subsequent contravention, prohibit such endorser from making endorsement in respect of any product or service for a period which may extend to 3 years. Now, when the central authority is satisfied after investigation that any person is found to publish or is a party to a publication of a misleading advertisement, it may impose on such person a penalty which may extend to 10 lakh rupees. Now, let's read about the appeal. Section 24 is talking about appeal, which is saying any person aggrieved by any order passed by the central authority under Section 2021 may file an appeal to the National Commission within a period of 30 days from the date of receipt of such order. Right? If there's an order passed by the central authority, you're not satisfied, then you will be given 30 days time to file an appeal to the National Commission. Okay, now we'll be reading about product liability under Consumer Protection Act 2019, which is saying product liability is the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold or by deficiency in services. Right. So product liability is basically under this, they're talking about the liability of the product manufacturer or the product service provider or product seller. Right. So here they're talking about the liability of those who sell any product or services which are faulty, right? Which are defective in nature, to compensate for any harm caused to the consumer, right? So against whom action can be taken if the product liability is upheld? Then Section 83 is talking about it, and it is saying that the product liability is upheld, then the case can be filed against product manufacturer, product service provider, product seller. Now, exceptions to product liability action. Let's see. Section 87 clause 1 is talking about it, and is saying a product liability action cannot be brought against the product seller if at the time of harm the product was misused, altered, or modified. Second, if any product liability action based on the failure to provide adequate warnings or instructions, the product manufacturer shall not be liable if the product was purchased by an employer for use at the workplace and the product manufacturer had provided warnings and instructions. Right? Suppose if you're buying and the seller has already told you the warnings or whatever instructions which were relevant with respect to that product or services, if he's already telling you when he's selling it to you, then his liability, he will not be held liable. Right? The product was sold as a component or material to be used in another product, and necessary warning or instructions were given by the product manufacturer to the purchaser of such component or material, but the harm was caused to the complainant by use of the end product in which such component was material was used. See, the product was one which was legally meant to be used or dispensed only by or under the supervision of an expert or a class of experts, and the product manufacturer had employed reasonable means to give warnings or instructions for usage of such product to such expert or class of experts. B, the complainant, while using such product, was under the influence of alcohol or any prescription drug which had not been prescribed by a legal practitioner. Right. So in these two cases also, wherein while selling the product or services, the seller had already warned you regarding the supervision of an expert, which will be necessary with respect to this product or the services. He has already warned you about this. And in such case also, the liability of the manufacturer or seller will be exempted. And if you use these products or avail the services while being drunk or being under the influence of alcohol, then also in such case, the liability will be exempted. Now, let's talk about mediation. In the earlier law, in the old legislation, we did not have concept of mediation, but now in this new law, mediation has been introduced, and Section 74 is talking about it. And it says, Section 74 talks about consumer mediation cell, and it empowers the state government to establish a consumer mediation cell to be attached to each of the district commissions and the state commissions of that state. Right? Mediation cells to be attached to district commission and the state commission. Central government also empowers to establish a consumer mediation cell to be attached to a national commission and each of regional benches. Right? So mediation cells will be there with respect to all three: district commission, central commission, and national commission. Every consumer mediation cell shall maintain a list of impaneled mediators. So these are the requirements which these mediation cells have to maintain. They have to maintain a list of impaneled mediators, a list of case handled by the cell, a record of proceeding, and any other information as may be specified by the regulations. Every consumer mediation cell shall submit a quarterly report to the district commission, state commission, or the national commission. They have to send their quarterly report to the district commission, state commission, national commission. It is mandatory. They have to follow these rules. So now let's read the section. Which section talks about what? We'll not be reading what's inside the section. Only we learn these sections by numbers. Section 75 is talking about empanelment of mediators. And it is saying that these mediators will be empaneled for 5 years. So empanelment is for 5 years. A duty of mediators to disclose certain facts is given. Duty to disclose certain facts is under Section 77. Section 78 is talking about replacement of mediator in certain cases. And Section 79 is talking about procedure for mediation. So they are saying basically while mediating, these mediators have to follow the principle of natural justice, and they have to complete within the time given in the regulation. Any matter which is sent over to them, they will have to complete it within the given time period in the regulations by which they are governed. Right, now, let's see settlement through mediation, which is talking under Section 18. And it is saying, pursuant to mediation, if an agreement is reached between the parties with respect to all of the issues involved in the consumer dispute, or with respect to only some of the issues, the terms of such agreement shall be recorded in writing and signed by the parties to such dispute or their authorized representatives. Mediators shall prepare a settlement report of the settlement and forward the signed agreement along with such report to the concerned party. Now, in case when no agreement is reached between the parties within the specified time, or the mediator is of the opinion that settlement is not possible, he shall prepare his report accordingly and submit the same to the concerned commission, right? So he has to submit this report also. If he's not satisfied and he's of the opinion that settlement cannot be done in such case, then he shall state that thing and send his report to the concerned commission. Right. Now, Section 81 is talking about recording of settlement and passing of order. If Section 81 is saying if the settlement is being done or is being arrived at by the mediation and the order is being passed accordingly, then Section 81 is talking about that. Now, we'll be reading the redressal mechanism. Suppose when the consumer is not satisfied with the services or the goods that he has availed, or he found some defects or deficiency in the services, what all he can do, where all he can go and seek the relief, where he can go to get the redress, where he can go to seek the relief. So this we'll be reading through redressal mechanism. What all redressal mechanism has been given to the consumers, this we'll be reading now. So basically 3 redressal mechanisms are there for the consumer. First, we'll be reading about district commission. Section 28 is talking about the district commission, which is saying state government has the power to establish a district consumer dispute redressal. So who is the appointing authority? State government, right? This is District Consumer Dispute Redressal Commission, to be known as District Commission. In each district of the state government may also establish more than one district commission in a district. So, state government will be appointing these district commission, and in each district there can be more than one district commissions. Each district commission shall consist of a president and not less than 2, and not more than such number of members as may be prescribed in consultation with the central government. Now let's read about the jurisdiction of district commission. Right. Section 34 is talking about the jurisdiction of district commission, which says if the matter does not exceed the value of ₹1 crore, then the matter will go to district commission. Earlier, this amount was, I think, 10 lakh rupees, but now in the 2019 Act, this amount has been exceeded to 1 crore rupees. And a complaint shall be instituted in a district commission within the local limits of whose jurisdiction the opposite party or each of the opposite parties, where there are more than one at a time of the institution of the complaint, ordinarily resides or carries on business or has a branch office and personally works for him. So where all? So this section is basically telling you that what is the pecuniary limit and where all the cases can be filed. It can be filed at in the place within the local limits of whose jurisdiction the opposite party ordinarily resides or carries on business or has a branch office or personally works for GATE. Now, under this district commission also, you can go for mediation, and section 37 is talking about reference to mediation, which is saying at the first hearing of the complaint, after its admission or at any later stage, if it appears to the district commission there exists element of a settlement which may be acceptable by the parties, then it may direct the parties to give in writing within 5 days consent to have the dispute settled by mediation. So what it's saying is, when you go to dispute district commission and therein you can, if the parties think that they can go for mediation, and if they're willing to go for mediation, then they have to write about it, that they're willing to go for mediation within 5 days. And it has to be in writing that, if the consent is given, then the matter will be solved by mediation. Now, appeal against order of district commission. Suppose the order of district commission is come. Now you're not satisfied by the order. What you can do? You can go for appeal, right? Any person aggrieved by an order made by district commission may prefer an appeal against such order to the state commission within 45 days. So what is required? What is mandatory in this? That within 45 days, if you are not satisfied by district commission order, file an appeal to state commission. And state commission may entertain an appeal after the expiry of the said period of 45 days. If it is satisfied that there was sufficient cause for not filing within that period, so within 45 days, you have to file an appeal, and the continuation of delay will be given, like the time period will be extended, you will be given time beyond 45 days if the state commission is satisfied that there was sufficient cause for not filing the case within 45 days. If you can prove that, then you can file case even beyond 45 days. Now, conditions for appeal before state commission, which is for making an appeal to state commission, person who is required to pay any amount in terms of an order of the district commission shall first deposit 50% of the amount in the manner as may be prescribed. An appeal cannot be made if the parties have already agreed for settlement through mediation. Right? So, suppose you are not satisfied with the district commission order, so you'll definitely go for appeal. That is to say, because of course, when you're going for appeal, that means definitely you must have been asked by the district commission to pay something. By the order of the district commission, you must have been asked to pay the amount to the consumer, which he must have asked. So what this is saying, if you're filing an appeal, first of all, you'll have to pay the 50% of the amount which was asked by the district commission, which was asked by the district commission to you to pay, right? And secondly, it is also saying that if you agreed for settlement, then also you cannot go for appeal. Now let's come to the second redressal mechanism, which is state consumer dispute redressal mechanism. It is given under section 40, which is saying state government, herein also state government is the establishing body. And this saying state government has the power to establish a state consumer dispute redressal commission to be known as a state commission in the state. Each state commission shall consist of a president and not less than 4 or not more than such number of members as may be prescribed in consultation with the central government. Now let's read the jurisdiction. Section 47 is talking about the jurisdiction of the state commission, and which is saying it will have the jurisdiction to entertain all the matters which exceeds 1 crore rupees value but does not exceed 10 crore rupees. So here the jurisdiction is between 1 to 10 crore rupees. If the value of your dispute is 1 to 10 crores, then of course you can file the matter directly in the state commission. And complaints against unfair contracts where the value of the goods or services paid as consideration does not exceed 10 crore rupees. On the similar point they're saying, and appeals against an order of any district commission within the state. So jurisdiction where when in which all those conditions you can go to state commission if the disputed if the dispute value is between 1 to 10 crore, or if you're aggrieved by the order of the district commission, then also you can go to state commission. Now, section 50 is talking about review by state commission. Wherein you'll find a review also. It is saying state government has the power to review any of the order passed by it if there is an error apparent on the face of the record, either of its own motion or an application made by any of the parties within 30 days of such order. 30 days is important. So within 30 days, if the state commission file thinks that the order passed by the state commission was suffering through an error apparent on the face of the record, then it can go for review of its own order. Now, appeal to National Commission. So now, if you're not satisfied by the order of the state commission, then what you can do? Then of course you can go for an appeal to National Commission, which is given under section 55. And it is saying any person aggrieved by an order made by the state commission may prefer an appeal against such order to the National Commission within 30 days. Right? See. Great. Just a second. Herein what they're saying is, herein you can go for an appeal under 30 days. If you're not satisfied by the order of the state commission, then of course you can go for an appeal to the National Commission within how many days? 30 days. Second, National Commission may entertain an appeal after the same thing. If it means condonation of delay will be there. If, see, in the earlier case, 45 days, you were supposed to file appeal within 45 days. But if you're filing an appeal to National Commission, then what you can do is, then you'll have to file within 30 days. If filing appeal to State Commission, file it within 45 days. If filing to National Commission, file it within 30 days. If you can prove by justified grounds that you will not file an appeal within 30 days, then court may grant you days beyond 30 also. Right. Now, let's read conditions for appeal before. Now, we will be reading condition. There is no. It should be state national commissions, right? Now, for making an appeal to a national commission, person who is required to pay an amount in terms of an order of the state commission, similar thing that they're talking, that they here also they're talking. If you are filing again an appeal to the national commission, if you're filing an appeal to the national commission, then herein also you will have to first submit the 50% of the amount that was being asked by you by the state commission to pay under that order. So 50% of that amount first you pay in this national commission, then only we'll be entertaining your appeal. Right? An appeal shall lie to the national commission from any order passed in appeal by the state commission if the national commission is satisfied that the case involves a substantial question. So here this is also very important. Substantial question of law has to be there. Submit 50% of the amount and file within 30 days. Okay. An appeal may lie to the National Commission from an order passed ex parte by the State Commission. If the State Commission passes any order ex parte, then also National Commission can entertain that issue, entertain that appeal. Now let's read about establishment of National Commission. Section 53 says, the earlier two commissions, district and the state commission, they were established by central government. This National Commission is established by central government, and it is saying, wait, let me find the cursor. Just a second. And it is saying section 53 second. Wait. Yeah. Section 53 is talking about establishment of National Commission. It is saying central government has power to establish National Commission, Dispute Registration Commission, which will be known as National Commission. And the composition of National Commission is 54. Section 54 is talking about the composition of National Commission, which is saying it shall consist of a president and not less than 4 and not more than such number of members as may be prescribed. Jurisdiction of National Commission. Section 58 is talking about jurisdiction, and it is saying that National Commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceed 10 crore. So, if the matter is below 1 crore, it goes to District Commission. If it is between 1 to 10 crore, it goes to State Commission. And if the matter is above 10 crores, then you can go to National Commission. And complaints against unfair contracts where the value of the goods or services paid as consideration exceeds 10 crore, then also you can go to National Commission. Appeal against the order of any state commission, appeals from any of the state commission will also go to National Commission. Appeals against the order of the central authority will also go to National Consumer Commission. Now, appeal against the order of National Commission. Section 67 is talking about where will the appeal from the orders of National Commission will be go. It is saying any person aggrieved by an order made by the National Commission may prefer an appeal against such order to the Supreme Court. So, what is happening? From District Commission, you're going to State Commission. If you are not satisfied by State Commission, then you go to National Commission. Now, what happens if you're not satisfied even by the decision of the State National Commission? Then you have the right to go to Supreme Court within the period of 30 days. Here and also you are given 30 days to file an appeal. Supreme Court may entertain an appeal after the expiry of the set period of 30 days if it is satisfied there was a sufficient cause for not filing within that period. That is, Supreme Court will also give you an extension beyond 30 days if you can satisfy the court that you had sufficient ground for not filing the case within 30 days. Right. No appeal by a person who is required by law to pay. No appeal by a person who is required to pay any amount in terms of an order of the National Commission shall be entertained by the Supreme Court unless that person has deposited the 50% of that amount in the manner as may be prescribed. So herein also this condition is important. If you're filing an appeal before Supreme Court, first of all, pay the 50% of the amount that you were asked by the National Commission to pay by its order. Limitation period. Section 69 talks about the limitation period. It is saying District Commission, State Commission, or the National Commission shall not entertain or admit a complaint unless it is filed within 2 years from the date on which the cause of action is arising. Right. However, Complaint may be entertained if there was a sufficient cause. See what they're saying in any of the commission, state, district, or national. If you want to file a case, you'll have to file it within 2 years from the date on which the cause of action has arisen. And this period may be extended if you're able to prove that you had sufficient reason for not filing it in within 2 years. Yeah, and these are the miscellaneous things that we are reading under this new law. And yeah, and it is also talking about, and the second thing that these are the miscellaneous things which we are reading. So under this act, we also find that experts to assist a national commission or state commission. It is saying that under 66, you'll find mention about assistance to experts or state commission. And it is saying where the national commission or the state commission or an application by a complainant or otherwise is of the opinion that it involves a larger interest of consumer, it may direct an individual or organization or expert to assist the national commission or the state commission. Section 71, it says every order made by the district commission, state commission, or the national commission shall be enforced by in the same manner as if it were a decree made by a court in a suit before it. Like every order passed by state, district, or national commission shall be taken in a manner as if it were a decree by a court in a suit before it. Right? Now, penalty for non-compliance of order. Section 72 is the penal provision, which is saying if you do not comply with the order of district commission, state commission, or national commission, then you shall be punishable with an imprisonment for the term which shall not be less than 1 month, but which may extend to 3 years. So what is the penalty? Minimum is 1 month and maximum it can go up to 3 years, or with fine, and which shall not be less than 25,000 rupees, which may extend to 1 lakh rupees. So what is the penalty? From 1 month to maximum 3 years, and fine of 25,000 to 1 lakh rupees, right? Or both can be given. So this is it. So this is it for today's lecture, and I tried to cover the important aspect of this subject, and if you read them and learn them, it will be sufficient for this exam. Thank you.